Well, welcome everyone to this meeting of the Peace Alliance Winnipeg in a discussion series that we've set up to discuss Canada's position in the world, its actions in the world. So this is the first webinar, and it's on the question of making mining companies accountable. Just to begin with, I'd like to thank Radhika Desai and the Geopolitical Economy Research Group at the University of Manitoba for arranging the Zoom call. Thank you, that's of great assistance. And thank you. So this is the first, as I said, in a series of webinars on Canada in the world. The need for a series to examine Canada's role in the world arose from the Peace Alliance Winnipeg's annual general meeting, and the realization that this topic needs a thorough examination as part of building public opinion to affect the change needed in Canada's actions abroad, and particularly its foreign policy that more often than not supports actions which are detrimental to the sovereignty and rights of other nations and peoples in the world. So this is our first webinar, as I said, and appropriately it begins on the question of mining, which is one of Canada's major actions in the world, and Canadian mining companies dominate the sector in many parts of the world. They are largely unregulated and able to profit from weak protection for the environment, workers, indigenous peoples, and human rights in many of the countries in which they operate. We're very pleased to have today Catherine Coumans of Mining Watch, who will talk about the struggle to make Canadian mining companies accountable. Catherine has co-managed Mining Watch Canada and coordinated the Asia Pacific program for 20 years. Catherine holds a PhD in anthropology and has published on mining in more than 15 peer-reviewed publications since 2008. Her work is from a rights-based perspective. She has worked in solidarity with communities and indigenous peoples affected by Canadian mining companies in more than 10 Asia Pacific countries. She has also provided her expertise to governments and legal bodies. Mining Watch Canada is a founding organization of the Canadian Network on Corporate Accountability, where Catherine provides strategic leadership on its steering committee. So without any further from me, I would welcome Catherine to begin her presentation.
Thank you. I'm just going to try to share my screen. So thank you very much for this invitation, and for all of you coming out on a Saturday in the summer. I'm very impressed with the people that have made it today. So let me just start with something that you all know. Of course, you all know that for many centuries, wealthy European countries used to send out their ships to bring back the valuable goods from around the world to enrich the home countries. The ship on the left here is one of the Dutch East India Company. This was a company that was set up in 1602. So it's one of the very first multinational corporations in the world, probably the first. It's certainly the first to have ever issued stocks. But this company, this corporation, was granted a monopoly on trade with the East Indies by the Dutch government. So right from the very beginning, corporations and governments have been entwined. Now, mining is Canada's corporate face abroad. And Canada's corporate mining executives don't go around by ships anymore. They fly around the world making deals, but always very much supported by Canadian government institutions, such as embassies, by government policies, such as the policy to protect and promote the interests of Canadian companies operating overseas, by financing, for example, through Export Development Canada, and even through our official development assistance, and through taxpayer dollars. For example, all of us who have are in the Canadian pension plan are supporting Canadian companies. The picture on the left here, I'm just going to briefly tell you who is on this picture. This is the modern day corporations going around the world, because I'm going to come back to this picture later on. So on the far left is Thornton. He is the chairman of the board of Barrick Gold. Then you have then President Magufuli of Tanzania, and the man standing to his right is the Canadian ambassador in Tanzania, who had set up this meeting. And this meeting was held at a time when Barrick Gold was in a lot of trouble in Tanzania, both for its human rights record, but also for non-payment of taxes. So just briefly, Canada's mining footprint in the world. This is actually from Natural Resources Canada, which describes the role that our companies play around the world as the role of the distribution of Canadian mining assets. And so just briefly, about 47% of the world's public mining companies are listed on Canadian stock exchanges. So the Toronto exchanges are home to more mining companies than any other stock exchanges in the world. There's about a total of 1,290 Canadian mining and exploration companies, and half of these have overseas operations. Canadian companies were present in 96 foreign countries in 2019. That's the last year that I have records for. And these mining assets abroad, as Natural Resources Canada calls them, account for about 2/3 of the total value of Canadian mining assets. So 2/3 of the value of Canadian mining assets is overseas. And it's maybe interesting just to note that when Canada talks about Canadian mining assets and the value of Canadian mining assets, this is not just the mineral properties that are owned or leased by our mining companies, but also things like deferred exploration expenses. So if they can make deals with the governments where they're operating, very often in developing countries, to defer paying taxes, for example, or paying exploration expenses, then that's considered an asset. And also if they can defer royalties, that's considered an asset. And a large portion of the value of these Canadian mining assets is situated in the regions of Latin America and the Caribbean. That is the largest portion. This portion accounts for about 46.5% of Canadian mineral assets abroad, with a value of $82.5 billion in 2019. So, given how widespread Canada's mining presence is in Latin America, I'm going to briefly look at some of the human rights impacts on the people who are trying to defend their communities and environments from the often very serious and long-term impacts of Canadian mining operations. And I'm going to turn to a really wonderful publication called The Canadian Brand. This was put out by the Osgoode Law School, and they have a justice and corporate accountability project. And they did a great piece of research looking at the violence and criminalization between 2000 and 2015 of people from the region, from Latin America and the Caribbean, who are trying to protect their livelihoods, their lives, their land, their water from the impacts of Canadian mining companies. And they recognize that the research that they did and the findings that they have are probably just the tip of the iceberg. Each of their findings had to be verified by 2 independent sources. So there's undoubtedly a lot more out there than what they've actually recorded. So they recorded incidents involving 28 Canadian mining companies. These incidents included 44 deaths, 30 of which they classified as targeted, 403 injuries, 363 of which occurred during protests and confrontations between people and the companies, 709 cases of criminalization of people who were opposing a mining project, including legal complaints, arrests, detentions, and charges, and a widespread geographic distribution of documented violence. The deaths occurred in 11 countries, injuries were suffered in 13 countries, and criminalization occurred in 12 countries. We know that these same impacts are experienced all around the world where Canadian mining companies operate. And I know that because having worked at Mining Watch for 20 years, I have colleagues that work in Africa and colleagues that work in other parts of the world, and it's the same story over and over, and unfortunately has not changed in 20 years. So I'm going to give you two brief examples from my own work in Asia Pacific and in Africa. So both examples are from Canada's biggest gold mining company, Barrick Gold. Some of you may have heard of them, of this company. The first example is from Papua New Guinea. This is the Porgera mine in the highlands of Papua New Guinea. This is a very remote region. It's very high up in the mountains. It's what they call a cloud forest. It's right on the edge of where agriculture is possible in Papua New Guinea. Barrick Gold has a mine there that has been unbelievably problematic from an environmental point of view. If you can see, I don't know how good your screen is, but if you can see that reddish flow on the left of the picture of the mine, that is the tailings from the mine. And those tailings are just spewed straight into the environment. There's no containment at all. And they end up in an 800-kilometer long river system and flow all the way from the highlands of Papua New Guinea into the sea and have an impact throughout that entire region, which is unbelievable. This would be absolutely not allowed to happen in Canada. And in fact, it shouldn't be allowed to happen in Papua New Guinea either, but a lot of pressure was put on the Papua New Guinea government when the mine got started. And so, standards that actually existed in Papua New Guinea were altered in order to allow this to continue to go on. And in fact, the water quality doesn't have to meet Papua New Guinea standards for water quality until 160 kilometers downriver. So the 160 kilometers is what they call a mixing zone. So the environmental footprint is huge. On the left of, or on the right of this picture, you see something that looks like steps. That is actually waste rock. And that waste rock surrounds the mine. There's valleys all around the mine, and that waste rock is in those valleys. And it is engineered to move like glaciers, and it will be emptying itself again into river systems around the mine for hundreds of years, even after the mine is shut down. The problem with all this waste around the mine is that this is where people live, and they have to cross these waste flows to get from one village to another, or just even to get from their village to whatever garden they have left for agriculture. And when they do that, they are subject to abuse by the mine security. And the mine has both private security and police of the state, which they house and feed and clothe. So they have a memorandum of agreement with the state in order to use their police forces. And these security forces, both private and public, have been brutal for decades at this mine. They are killing people, including children. They are raping and gang raping women. There's a very long history of this. It's been very well documented now, including by Mining Watch Canada and by Harvard's legal clinic and Columbia University's legal clinic. It's one of the most brutal situations that I'm aware of in my knowledge of mining by Canadian companies. And Barrick was in denial for years, just plain denial. And the person you see on the right there is Jethro Tulin. He's actually at Barrick's annual general meeting there. We brought people in from Papua New Guinea for 4 years straight, and they stood up at Barrick's annual general meeting and told the whole board of directors and all the shareholders, your security guards are killing our men and boys, and they're raping and gang raping our women. And there was complete denial from the company for many years. So that's one example. I just thought I'd throw this slide in because this is what's happening right now, this month. That mine's permit to mine actually expired in 2019. And at that point, the Papua New Guinea government decided not to renew the license to Barrick. And you would think that this would be a right that a government would have, that a government could say, you know what, this is not working. People are very angry. People are very much opposing this mine. We're not going to renew your license. But Barrick has been fighting this tooth and nail ever since the permit was not renewed in 2019. And it eventually also taking legal action against the Papua New Guinea government. And for a long time, the Papua New Guinea government held fast and said, no, we're not going to renew this license. We have that right. But now they've caved. And so what you see, and that is happened because of legal threats by Barrick. And in fact, the prime minister of the country, James Marape, actually said that when he said that they were now going to sign an agreement with Barrick to have Barrick stay involved with the new mine as it goes forward again. Marape actually mentioned the legal action that had been taken and essentially said that the state of Papua New Guinea could not afford to face Barrick, not only in courts in Papua New Guinea, but Barrick has also initiated a lawsuit in international arbitration. So in an international tribunal outside of Papua New Guinea, and it would have been very expensive for the Papua New Guinea government to defend itself. And that was named as a reason. And so what you now see is the CEO of Barrick Gold, Mark Bristow, on the right in the picture with the three men, and the Prime Minister on the left, with the famous but agreement that no one has actually seen yet. And what you see on the right are people protesting against the continued operation of Barrick. And one of the things they say is, pay first before you dive into the pot of gold. And what they mean by that is that there's all these people who've been harmed by the mine, both by houses that have been burnt down by chemical spills, but also the people who've been shot or beaten up or raped, whose cases have never been resolved, who've never been acknowledged by the company as having been harmed by the company. And so they're saying you have to deal with these human rights cases before you can continue mining. So now to move from Papua New Guinea to Tanzania, and we have another Barrick mine, and we have the exact same situation. So this is not just a one-off, this is systemic. After having worked at the Papua New Guinea mine on the ground, I started going up there regularly in 2006, and have been going up there regularly since, documenting the abuses. In about 2013, discovered that the very same thing was going on at Barrick's mine in North Mara in Tanzania. Again, security guards and police who are being brought in to secure the mine through a memorandum of agreement with the state, abusing men, shooting and killing and beating up men and raping women at this mine as well. Now, there was a lawsuit that was filed here, and Barrick settled out of court in 2015, but the situation continued. So I've actually been doing human rights assessments here from 2014 yearly until 2019, and then of course last year with the pandemic I couldn't go. But it was clear that after the lawsuit was over, nothing changed, everything continued. And so now there's a second lawsuit with new victims who, and again, this is going through the courts. It's going through the courts in the UK because at the time Barrick was running this mine through a subsidiary in the UK. Okay, so what I want to do now is switch gears after giving you a bit of a quick picture of the involvement of Canada in mining around the world, and also the very serious criminal acts and environmental degradation that is occurring even by our biggest gold mining company. So it's not a matter of little ones, being the rotten apples, and the big companies are fine. This goes right to the very biggest companies. So we'll switch now, and I'm going to go through a bit of a background for you of the attempts by civil society, and that I include in that academics and lawyers and unions and NGOs, faith-based groups that have come together in an entity called the Canadian Network on Corporate Accountability. Now, this story I'm going to start telling you starts in 2005, and the Canadian Network on Corporate Accountability didn't yet exist, but came out of these early actions. So if we go back to 2005, and look at the situation at that time, both with respect to judicial accountability and non-judicial accountability mechanisms in Canada for abuses perpetrated by Canadian mining companies operating overseas as they existed at that time. So at that time, in 2005, there had only ever been one legal case brought in Canada, and it was 8 years earlier, it was 1997, against a company called Cambior, for a major mine waste disaster in Guyana, which had occurred in 1995. The Quebec court that heard the case ultimately sent the case back to Guyana as being the more appropriate forum, and ordered the plaintiffs to pay Cambior's legal costs of having just tried to bring the case in Canada. So the outcome of this case, this very first case that was brought, caused a really long-term chill on legal action on transnational litigation in Canada, not only because the case was sent back to Guyana, but also because it was very expensive for the plaintiffs. They had to actually pay the legal fees for Cambior. Another case against a Canadian mining company for overseas harm would not be filed until 2009, so 10 years after that first attempt. 8 cases have now been filed and 3 are still before the courts. And just to mention that of the 3 that are still before the courts, a number of the plaintiffs for these are also women who have been raped by security at a Canadian mine, in this case in Guatemala. So this is a widespread problem. So also in 2005, Canada had already something called a state-based non-judicial grievance mechanism. So in addition to bringing your case in court, you could also bring your case to this state-based non-judicial grievance mechanism. And it's called the National Contact Point for the OECD Guidelines for Multinational Enterprises. Now, this mechanism had been in place since 2000. All OECD member countries are required to have such an office to hear complaints against their companies operating overseas for breaches of the OECD guidelines. Canada's National Contact Point has always been housed in Foreign Affairs. So just to briefly give you a sense of what this body is about, the NCP does not carry out investigations. It does not make findings of fact. It does not ensure the provision of remedy for those who've been harmed. It can offer what they call their good offices for mediation between the parties, but even that it rarely does. It has always been very protective of corporate reputations, and it has largely been considered harmful by the communities and workers who have attempted to bring cases before this office. In 2005, there had been 7 cases brought before the NCP. 3 of these were brought by Canadian unions. 5 of the 7 cases were against mining companies. So as early as 2005, with this body, this non-judicial body, 5 of the 7 cases were against mining companies. 4 of these cases were dismissed by the NCP outright, and none of them resulted in findings of fact or remedy for those who had been harmed. And sadly, this track record of Canada's NCP has continued to this day. There have now been 21 cases filed, so that's about a case a year. And it's amazing that people continue to file cases, I must say, given how horrible this office really is in terms of its track record. 17 of the 21 cases have been against Canadian mining companies. So that gives you a fair idea of how large the problem is in regard to Canadian mining companies. Most of these cases have been dismissed. None have resulted in remedy for those harmed. Yeah. So also in 2005, it's important to know that there was another avenue opened up for complaints, and that was a parliamentary committee that was willing to hear some complaints from Canadian, from people from the Philippines, indigenous Sabanan, who had been harmed by a Canadian mining company called TVI Pacific. And so what happened was this committee heard this complaint and issued a report. And that report is still considered a high watermark. In 2005, this report came out, and one of the things, the recommendations in this report was to strengthen the rules and the mandate of the Canadian National Contact Point to enable it to respond to complaints promptly, to undertake proper investigations, and to recommend appropriate measures against companies found to be acting in violation of the OECD guidelines. So this was the recommendation in 2005, and clearly that recommendation was not acted upon. The recommendation also was to establish clear legal norms in Canada to ensure that Canadian companies and residents are held accountable when there is evidence of environmental and/or human rights violations associated with the activities of Canadian mining companies. Now, the Canadian government was supposed to have responded to these recommendations, and I can tell you that that did not happen. The Canadian NCP is still operating as it is, and there are still not clear legal norms in Canada to ensure better behavior by our Canadian companies. What did happen was in 2006, there was something called National Roundtables on Corporate Social Responsibility and the Canadian Extractive Industry in Developing Countries, a mouthful. These roundtables were held throughout the country. The Government of Canada created an advisory group, which included academics and union representation and representation from civil society. And in 2007, there was an advisory group report that came out of this. And some of the recommendations from that advisory group report were that in light of the alignment between civil society and industry participants on the need for an ombudsman to be established, the advisory group has focused its recommendations on the creation of this office. And so what's important to understand here is that that advisory group report was actually a report that was a consensus, had consensus recommendations from industry and civil society. Importantly for that report was the fact that both industry and civil society agreed that the national contact point was not a good non-judicial grievance mechanism and probably couldn't be fixed. And that rather than having the national contact point continue or try to fix it, we should create something new. And the advice was to create an ombudsman. And the advice was also that the ombudsman would have a function, a mandate to do fact-finding. There was general convergence around the importance of having an independent investigative function to promote transparency and to produce impartial evidence. So unlike the national contact point, the ombudsperson would do actual investigations and make findings of fact. And the advisory group, as I said, believed that an enhanced national contact point could play an important mediation role, a function that would not be assigned to the ombudsman office. And that's important. So the agreement was that the ombudsman's office was going to do the investigations and the findings of fact and make recommendations around remedy, whereas the NCP, if it continued to exist, could play a mediating role. So in 2009, after 2 years of ignoring the consensus report that came out from both industry and civil society with its recommendations, and this was the government's own multi-stakeholder advisory group, the government in 2009, and this was of course the Conservative government, created something that was not an ombudsman, but rather a CSR counselor for the extractive sector. So rather than creating the ombudsperson, they created a CSR counselor for the extractive sector. The ordering council mandate of the CSR counselor was so weak that it set the office up for failure. For example, it provided no way for the CSR counselor to compel companies to participate in investigations. So again, it should have been able to do investigations, but there was no way to actually make companies participate. The office was again housed under Foreign Affairs, just like the National Contact Point. The first CSR counselor did try to carry out investigations. She received 6 complaints against mining companies, including a strong one regarding labor rights, but she was not able to advance any of these complaints. Partway through her second term, she quietly quit. After remaining vacant for over a year, the new CSR counselor was appointed under the same weak ordering council mandate. This new counselor never took any complaints, and the office was finally disbanded in 2018. The CSR counselor's office, when it was disbanded, it was at the same time that the Trudeau government created, finally, the Canadian Ombudsperson for Responsible Business Enterprises, which is called the CORE. So during the elections in 2015, the Canadian Network on Corporate Accountability asked all of the parties, if they were to be elected, would they create the ombudsperson that was asked for in the 2007 Consensus Advisory Report? And the Trudeau government said that they would. And so when they got elected in 2015, we put a lot of pressure on the government to say, okay, you've said that you're going to create this office now, you have to come through. And it took, again, a lot of years. So in 2015, they were elected. By 2018, finally, there was an announcement that this office was going to be created. And when the Ombudsperson's office was announced in January of 2018, there was a firm commitment to civil society and labor groups that had lobbied for the creation of this office through the Canadian Network on Corporate Accountability and to Canadians from Minister Champagne of International Trade. He and the Government of Canada committed that this office would be independent of government and that it would have the necessary powers to investigate claims of wrongdoing by Canadian extractive companies, including the powers to compel documents and witness testimony. And this is critically important. one of the things that we saw time and time again with people's complaints being brought to the national contact point is that the national contact point would take information from the people and it would take information from the company. And even if people brought a lot of evidence, and in one case that Mining Watch brought, because Mining Watch brought 5 cases to the national contact point, and they were all fruitless. And the very last case we brought, and since then we've stopped using that office, but the very last case we brought, we actually had a lawyer involved to help us, you know, with an overwhelming amount of evidence to make sure this case would proceed. And the only thing we were asking for is the only thing the office could offer is mediation. A chance for the people who are being harmed to sit down with the company, the Canadian company. You would think that wouldn't be too hard. And I remember the lawyer saying, this is more evidence than I normally need to file a case in court. And it was dismissed by the national contact point again. And so when we were lobbying for the ombudsperson, we said, look, this is a really big problem, because it was dismissed simply by the company saying, no, those things they're saying are not true. Despite the evidence, we as the company are saying it's not true. And the NCP said, well, the company said it's not true, so we're going to dismiss it. And so what we said is, you know, an ombudsperson would need to have the power, the investigatory power, to compel documents from the company and compel witnesses from the company under oath. And that way you level the playing field. It's not just the company says it's not true and therefore it can't go anywhere. And there was a firm commitment by the government of Canada, and this was not easy. This took a long time to get this commitment, but there was a firm commitment from the government of Canada that this office would have those powers. In fact, it was on the website. It was in a number of different places. We have lots of screen saves of this commitment. And yet, and it took over a year for them finally to hire an ombudsperson. And when that ombudsperson was hired in April of 2019, her order in council mandate did not include the powers to compel witnesses and testimony. So the very teeth that this office needed were not included when she was brought in. And so this is the first ombudsperson who was brought in. This is Sherry Meyerhofer. She came in April 2019. As I said, she has no powers to compel documents or witness testimony. This means he essentially cannot correct the power imbalances that exist when communities or workers try to hold multinationals to account. In fact, her order in council mandate resembles very closely that of the failed CSR counselor office, which has finally been disbanded. And it also reflects a lot of the ongoing weaknesses of the national contact point, which I've also discussed. In fact, as the ombudsperson has developed her operating procedures over the last couple of years, it's become increasingly clear that she will be working very closely with the national contact point, both in Canada and in countries with national contact points where she may carry out investigations. It should be noted that while the ombudsperson initially did make repeated public statements indicating that she should be granted those powers to compel witnesses and documents, in parliamentary hearings just held very recently on her office, and this was in February, so there have actually been parliamentary hearings on her office based after an electronic parliamentary petition by the Canadian Network on Corporate Accountability and its members. She refused to answer a question by saying that she needed to have those powers, and that's very disappointing. When she first came in, she agreed. She thought she was taking the job, and by taking the job, she would have those powers. And when she didn't have those powers, she agreed in the beginning that she did need them, and she was asking for them, and was open to the media and others that she needed to have those powers. But when she was asked in February in this parliamentary hearing whether she needed to have those powers, she was evasive. She made it sound like she could do her job without those powers. And this was shortly after her budget was substantially increased. During the same hearing, she described her position as, and I'm quoting, "What we're doing is good for companies and we'll be assisting them to be able to do their work better," end of quote. Although the office has not yet investigated any complaints, we are sufficiently concerned about her weak mandate and her own operating procedures to have issued a caution to communities and workers who may consider bringing a complaint to her office. So the Canadian Network on Corporate Accountability has actually issued a caution to communities to say, you know, We don't want more people to be going to this office as all those people who brought complaints against mining companies 17 times to the national contact point with no avail. So what are the lessons learned from this history of attempts to create mechanisms in Canada to hold Canadian companies to account? Our courts are more open than they used to be. There have been more cases filed now, although none of them have gone all the way through, so a precedent hasn't yet been set. There has been two, I think two of the cases were settled out of court. But there's 3 cases still ongoing, and so we'll see how those end up. So the courts have become a little bit more open, but it's really not through any kind of mandate. It's more just because they have every case has to argue why the case should be heard in Canada, and why the case should be heard against a Canadian company, even though it's a subsidiary that brought did the harm overseas. This interesting mechanisms or ways have to be found in each of these cases. It's not like our courts are actually open. So the lessons learned with respect to these non-judicial mechanisms, so we've now had the National Contact Point, we've had the CSR Council, and we've had the Ombudsperson. These are all mechanisms that have not been independent from the Government of Canada, which essentially sees its mandate as protecting Canadian corporate power. All have been subject to political influence that undermines accountability and protection for human rights. The National Contact Point still does not conduct investigations, make findings of fact, or provide access to remedy. The CSR Councillor did not, and the Ombudsman does not have a mandate that allows for compelling witnesses and documents, and so the Ombudsperson is hampered, both in evening the power imbalances between corporations and those bringing grievances, and in making solid findings of fact upon which to base recommendations for remedy. These weaknesses put community members at risk when they attempt to use the National Contact Point or the Ombudsperson to get determinations on their claims and/or remedy for harm done. The harm that people experience when they bring claims to these offices is not just the lost time and costs to engage these offices, and often these cases go on for years. Even before these non-judicial mechanisms, these cases can go on for years. But there's also lost opportunities to take other possibly more effective actions. So while they're engaged here, they don't have the resources and the time and the energy to possibly do something else that might be more effective. There's also a possible imposition on the people who bring the complaints of confidentiality, or as they call it, suspension of campaigning rules under good faith clauses in operating procedures that can hamper efforts to continue to try to stop the ongoing harm. So the National Contact Point in particular has these clauses so that while people are going through the National Contact Point procedure process, which again can be very lengthy, they're not supposed to be campaigning against the company or against the harm that they're enduring. And they're not supposed to be speaking about what's going on in the actual procedure that they're involved in. And the other very serious harm that has happened time and time again is public findings based on incomplete information, because the NCP cannot compel documents or witnesses, and now neither can the Ombudsperson, that can cause harm to the complainant's efforts to stop ongoing harm or to seek remedy, and can undermine their agency. In other words, once a case is dismissed by the National Contact Point, those who've been watching that case, and that can be, for example, socially responsible investors and others, will think, oh, it was dismissed, there must be nothing there. There must have been nothing there, even though there's been no investigation, there's been no finding of fact. It's been dismissed on other grounds than on findings of fact, sometimes simply because the company said that there's not a problem. And now others who've been watching that take that to mean that, in fact, the complaint that was brought was not valid. And that's actually really problematic. The final thing I wanted to raise with you was that just this month, or actually May 30th, just the end of last month, the Canadian Network on Corporate Accountability actually filed a draft legislation We made a public announcement of draft legislation that would create something called mandatory human rights due diligence in Canada. And what that would do is it would require, it would be legislation that would require of all companies, and we're not just talking about mining companies, but all Canadian companies, all parent companies based in Canada, to do due diligence, human rights due diligence, not just on their own direct activities, but on the activities of all of their subsidiaries and contractors anywhere in the world. They would have to do this human rights due diligence on an ongoing basis and report on this due diligence yearly. And that's important because hopefully just in doing that and in having to report on that, there would be a preventative action. You know, if companies are actually being told you have to look at the risks you're putting people to, all your operations. If your operations are putting people's human rights at risk, or the operations of your subsidiaries or your contractors, you need to actually be aware of that. And you need to take steps to mitigate that. And then you need to report on the risks that people are put at through your operations and the steps you've taken to mitigate that. And you need to report yearly. But perhaps equally important as this hopefully preventative action is a cause of action. So the regulations, the legislation would actually allow people who say that they've been harmed by a Canadian company or its subsidiaries or its contractors to take that company to court in Canada. So it would open the doors to Canadian courts much more widely than they are now. You would no longer have to try and find a way to argue that Canada is the appropriate forum, that the subsidiary was in fact controlled by the parent and therefore the parent should be taken to court in Canada. You don't have to make those arguments. You've been harmed. It's by a Canadian company or its subsidiaries or its contractors. You can file a case, a civil case in Canada. And so we've just launched that legislation. We're hoping it will be picked up by a member of parliament and possibly become a private member's bill. We have good hope that that will happen. And then we're in a long process of trying to push that legislation through to be adopted. And you can see, you know, there's been 20 years of trying to make the National Contact Point a better office than it is. We had, I don't know how many years of the CSR Council from 2009, and it was finally disbanded in 2018. So almost 10 years of the CSR Council, which was useless. Then we got the ombudsperson, and the ombudsperson was defanged. It wasn't given the powers it needed to actually be effective. You can imagine what we're asking for now is even more than what we've asked for in the past. We're asking for, you know, actual legislation as opposed to a non-judicial grievance mechanism. We're asking for access to our courts. It's going to be quite a battle, and we're going to really need the support of Canadians to make this happen because it's obviously always political. So thank you very much for your time today on a Saturday to listen to this story. I don't know how we're doing for time, but I have a video that I could show you. It's just 12 minutes. I'll let the moderator let me know whether that makes sense or not.
Time-wise, I would say that's fine. We're at about 10 to 1 right now. So when we had allotted till about 1:30. So why don't you show the video and then we'll take questions and answers.
Okay, let me see if I can quickly find it because that's always the trick.
While you're finding it, let me just say that the excellent presentation. And while I knew some of this, it was really eye-opener for me, the depth of the presentation. So very valuable contribution, I would say, to this work of trying to make Canada accountable.
Okay, I think I might be able to. Can you see that? Can you see my screen at the moment? Can you see?
Yes, silent no more. Women speak out about mining violence. That's what I see.
So this is a video that we made about the case in Tanzania that I referred to earlier, and I'll just let you watch this. And I'm happy to answer questions, of course, later.
In the north of my country,
can you hear this?
Tanzania is a mine that is owned by the biggest gold mining company in the world.
It's loud and clear.
Canada. Barrick runs the mine through its subsidiary Acacia Mining. The mine is on the land of the Kuria people, who are known for their skills in agricultural production and keeping large cattle herd. The Kuria of Nyamongo were also fortunate because they could supplement their income with easily accessible gold they found on their land. But when the mine started operations in 2002, the local villagers had lost so much of their land. They were pushed onto the margins of the mine with not enough land for their cattle or their agriculture. They also lost access to their gold. Poverty became extreme in the villages. In desperation, men, women, and even children started to eke out a living by scavenging for gold in the west from the mine, especially in the mountains of the west rock that surround the pits and take up even more of the Kuria's land. But poverty and desperation of the villagers around the mine has made them extremely vulnerable to exploitation and human rights abuses, particularly as the mine militarized, using both private security forces and Tanzanian police to guard the West Rock dams and the pits. Villagers tell of the mine security and police demanding payment before allowing them to enter the West dams. But when they are searching for gold in the West Rocks, the security forces violently target them. Men and women suffer severe beating, men are shot at and even killed, and women have been raped and gang raped. After many years, reports of extreme violence due to excess use of force by mine security and police reached the international level. In 2013, under threat of lawsuit, the mine put in place its own grievance mechanism to deal with the victims. The mine's grievance office is behind this wall. But most of the men and women who have received some compensation from the mine after signing waivers that take away their legal rights say the compensation is not enough to offset the harm they have endured, harm which have long-lasting consequences for them and for their dependents. Listen to the women themselves.
Familia kama nimesema kwenda kuzona. Sasa baada ya kwenda ninama kuzona, nikasikia mruzi. Askari awakao wamefukolo ni vitambaa vyekundu kichwani, gari limeshona. Baada ya kuwa limeshona, kujitahidi kukimbia mobile ndio hawa hapa. Nikashinda namna ya kukimbia. Ndipo wakawa wamenipiga kwenye mishipa nikawa nimepoteza fahamu. Baada ya kuwa nimepoteza fahamu, nikaenda kushtuka nikakuta niko hospitalini. Mama akaniambia tulia utasimulia, lakini hivyo amka nilikuta na maumivu makali sana, ambao aliyenifikia kwenye matako ya mbele. Maumivu ya matako ndio yaliyoniumiza sana ndani ya miezi miwili, ikiwa bado naumwa na kuporomoka damu. Nilikuwa mjamzito mimba miezi miwili. Natoka hapo, kila nikibeba mimba hazikai, kila nikibeba mimba zinaporomoka. Baada ya kuwa nimekaa hapo nikawa nauliza ndugu zangu hawakutaka kunijibu vizuri. Bali mzazi hawezi kupoteza, alikuwa ananiambia tu, ananiambia kisha tokea ni hivi na hivi. Kwamba uliletwa, mimi nilikuwa nimekaa nikaja kufuata ndio mbuni bloki. Amebako huko na mobile na maaskari, tunaenda tumemkuta yuko tabani tukamchukua. Ndipo nilipoongezwa maji chupani. Nilikuwa nimeenda kutokea na takataka. Ndio wali nipata toke kwa nini tuotumie. Sasa pale ndio tukiingiza pale ndio wakanikamata, wakaweka wani wa ndege, kaenda kaniambia shika jiwe. Basi nifanye mambo mabaya. Nataka kuangalia nikakoshi. Kana bila kuokoa tu kama siku ndio ya kupeleka tu nikaenda hata hivi. Kutoka pale tulikuwa tunaenda kuokota mawe mlimani wanapotupa uchafu wa zungu. Hapo tulipokuwa kwa hiyo askari walikuja wengi wakatuzunguka, wakakimbilia wakakosa, ndio tukakamatwa. Kwa wale watu ambao tulikamatwa wanaume ndio walikuwa wengi, mimi ndio nilikuwa mwanamke mwenyewe. Tukapelekwa, wakanipeleka kwenye kidungu. Baadaye nikakaa muda kwenye kidungu, wakanifunga vitambaa machoni. Kawauliza mbona mnanifunga vitambaa machoni? Wakasema tulia. ukilia tunakupiga bunduki. Ndio nikatulia, wakaanza kuibaka. Baada ya hapo waliniachia, gari ikaja, nikachukuliwa nikapelekwa kituoni. Nilala kituoni, kesho yake ndio nimetoka kituoni.
Nilienda kwa pata ya takataka. Kukimbizwa na matai. Akanikimbiza nikatoka, wakanipiga nikaanguka. Wakanilala. Mmoja alinilala kumwambia mwingine akasema acha sasa. Wakanipiga. Ndio nalima miti. Kashinda kutembea. Kanibeba kaniweka njiani, natafuta bodaboda, nikaenda zunguka kibia.
Alikataa kama hataki kuniona mbele ya macho yake, maana nimemzalisha kwenye umati wa watu. Toka hapo nilipogunduliwa ndoa yangu na kuachana kabisa na mume wangu, kwa sasa naishi maisha magumu sana. Naishi kujitafutia kwenye jamii. Ukienda kutafuta anaweza kusema kama unazalisha, anaweza kukupigia makelele shangwe, wengine wanakuzomea. Ukienda kuomba msaada wa kusaidia, na uzazi wangu umeharibika. Kila napobeba mimba zinatoka. Kila napobeba mimba zinaporomoka. Ndio tulichukuliwa na mgodi, tukaenda tukapimwa. Ndio mimi kaonekana nina maambukizi ya virusi, na mtoto wangu mdogo pia naye. Sasa nilienda nyumbani pale, mama kaniuliza kwangu umekuwa nini, nikamwambia kaniambia toka hapa nyumbani kwangu kama leo sitaki nilete, nimepata ugonjwa. Yaani hapa ndio aliangu nilitaka kukuli na sio ambaye kualijika, nikaenda nikapimwa, kakuta kuna ugonjwa. Baada kukaa kama miezi mingi, kama kipindi mume wako mimi tumeshaachana, mimi naangaika mwenyewe na watoto. Au kutoka na mwanangu nakaa kwa jirani kupiga story. Nikifika kwa jirani anaanza kusema nataka kumfundisha mke wake aende kwa kumlipo bako. Mbozo wa wazungu ni wanavyotuita. Sisi walifanta katuambia hivi watatusaidia. Tulipokwenda pale tukasaini, wakasema hivi nyie msaini, sisi tutawasaidia, tutawajengea nyumba, tutawanunulia uwanja, mtaishi na tutawapa ya biashara au mtafanya kazi mgodini. Tukasaini mkataba. Tulifanya na mgodi, tukaenda katuandaa, watatujengea, watoto watachukua watoto, kila kitu watatutengenezea. Sasa baada kufika pale tukaambia kwanza hivi watatujengea, watoto watasoma, watatupa kazi, watoto wasome mpaka mwisho. Lakini tukiona lolote tutajengea, tukiona lolote. Wengine mtoka anakuja na kuambia nataka hichi, tumeanza tununue hichi. Hamna. Jinsi walivyo kutusaidia, wanafanyia jiani watoto hawana mategemeo ya kuwasomesha hawa watoto. Na kitu cha kunisaidia ndio hawakunisaidia. Kana ndio walinitafutaje? Upande kunisaidia huko, walienda kunisaidia kivipi sasa? Yaani kile kibarua niliyojengea nyumba yangu ni jasho langu. Walienda kunipa adabu upya, tena kunifanyisha kazi upya. Wamenitendea jambo kubwa, tena wakaenda kunifanyia jambo lingine la kunipa kazi yao ya kufanya kazi. Kwa sababu mimi pale sijaona kwa kweli kitu walichonisaidia. Maana ningeacha hiyo kazi, ile heri ilikuwa kwamba ningekuwa naikusanya na ibana. Siku nikimaliza sasa nifanyie kazi yangu, lakini nilienda nikajituma, nikajijengea nyumba. Sasa wanatusaidia kivipi mama? Hata wao ndio wanatusaidia kivipi? Hawakutujengea nyumba, hawakutupa maandalizi yote. Hatujasaidia sasa. Kusaidia nyumba sababu tulikuwa pale mkataba. Hatusemi kwamba hivi tumesaini kuchukua mkataba. Tulifanya ngoma tukabeba mkataba yetu. Tukatatamana sasa tukasema leo kama hamtupi mkataba yetu, leo wakatuambia kwamba uende nyumbani, kesho mkija mnapewa mkataba, na kesho yake hiyo ndio tulienda tukapewa hiyo mkataba juu tumeshasimamisha kazi. Walitupa mkataba, wanatusimamisha kazi, walitupa mkataba, tumefanya hiyo kazi. Hapana, kazi ndio wametusimamisha, wametupa mkataba. Mpaka sasa hivi tumerudi kwenye mateso yale yale ambayo walikusema kwamba tumefanywa kulingana na hiyo tukio, sababu maisha sasa hivi tuliona imesha magumu sana. Nikitenda ambacho hata siwezi kukosa nikaenda kwa jirani kuomba. Hatukija kwangu upaone kama utanirudia. Sema tu ile mtu kukuta Afrika shida anapata kaina na jirani kangua anafaa. Ili ukifika kwangu utanirudia. Kwa maana ninapotembea sijiwezi hata siwezi kufanya kazi ni siwezi. Naomba nisaidie kabisa kwa familia yangu nitegemee nikiwa kama saa hizi ndio hivyo nimeacha sababu sina sehemu ya kuishi. Niishi kwa mtu wa mtu. Ile zamani ile nyumba nilikuwa kwa na kama nilijenga kaliuzwa. Wewe mnaomba nenda kasema hii nyumba nauza akauza hivyo hivyo. Nikabaki na tembea na watoto kama huko.
I maybe should have given more of a warning that there could have been triggers in that video. It's been a while since I've watched it myself. I hope everyone was okay. Maybe just to briefly say something about the video. You know, as I started out saying, you know, the harm that people experience as a result of Canadian mining companies, even big ones like Barrick Gold, it can be really severe. And it's unbelievable that, you know, in the 20 years that we've been trying to create a place in Canada where they could bring these complaints, they still don't have anywhere to go right now. Even the ombudsperson, when we finally got the ombudsperson after, you know, 15 years of lobbying for that, has been weakened to the point that she would not be able to hear these complaints. And well, the mandatory human rights due diligence that we now think would be the most important thing that we could possibly get, it will probably be an uphill battle. And yet people continue to suffer because of the activities of our companies. And as you saw in the very first slide of my presentation, while all of this is going on, while I have been to the embassy and discussed the harm that that mine was causing to the local communities, when the government of Tanzania wanted to increase the taxes, or just to get the taxes that they were owed, in fact, you see the ambassador actually broker a meeting between the chairman of Barrick's board and the president of Tanzania. They jump in when companies are being asked to pay their taxes, but they do nothing when people are being raped and gang raped and shot and maimed by the security forces of a Canadian mining company. So it's a very serious situation, and we don't have a serious response at this point. I'll leave it there and take your questions.
Thank you. I'd say it's a scandal is what it is in terms of Canada. Before you showed the video, I saw Rachel raise her hand. Rachel, do you have a question? Unmute yourself, please.
No, I was just clapping. I was saying, thank you. Sorry.
Okay, does any questions, please raise your hand. I see Radhika, you have a question, please. Okay, Radhika, go ahead.
Yeah, well, first of all, thanks so much for a fantastic presentation and very, very excellent film, very moving and of course, very hard hitting. And, you know, as Glenn was saying, you know, you've made us all know more. I also thought I knew a little bit about it. And I just wanted to, I guess I have one comment and one question. My question is, you know so much about the law around these things and so on. And I remember a few years ago reading Alain Deneau's work, you know, the guy. I can't remember now exactly what he was saying about, you know, what is it that makes the Toronto Stock Exchange so attractive for mining companies? If you could take us through that again, I think that's a very critical part of the puzzle. And perhaps you can also tell us if attempts have been made to direct activism at that, to see if something can be done there to prevent these sorts of atrocities and so on. And the second thing is, I'm so glad you showed that film in that film, you showed this little clip of how it used to be when the mining company was not there and people mined the gold that came freely down the river. I think that was very important because, I do a little bit of reading around these things, and I find that people just take it for granted that there are all these desperate sort of artisan miners, as they're called, or whatever, informal sector miners. And the impression that's given to us is these people are just desperate. What is hidden from view is that these people had access to those resources before. They were in a small way exploiting them and making a living out of them. And now it has been taken away from them and they have been reduced to looking for whatever mineral it is in these tailings and so on. So I just wanted to say that was such an important thing, and you should always emphasize that, because a lot of people who are actually studying this stuff don't know this. So that's what I thought I'd share.
Thank you, Radhika. Go ahead, Catherine.
Okay, I'll take these questions and then we can go on. So this is an ongoing question. So why is our stock exchange so interesting to mining companies to be headquartered here and to list on our stock exchange? And the answer is not as straightforward as it may sound. And this is probably why you've forgotten what was in Alain Deneau's book, because it's not a simple question. A lot of it has to do with the fact that because Canada has such a long history of mining being an expertise of Canada, because Canada was used as a colony of England to receive minerals and metals to be brought to England. So going back to the very first picture of my slide where you saw the ship in the 17th century bringing the goods from the colonies to Europe, Canada was one of those colonies, and mining and getting metals from Canada for the use of the European countries, particularly France and England, actually led in the end to an expertise around mining in Canada. And it's continued to be one of our flagship industries. And because of that, there's a concentration in Toronto in particular, but also in Vancouver, of expertise around mining. So if you're headquartered in Canada, or if you're listing on the stock exchange here, you have ready access to legal expertise. And honestly, almost all of these abuses that happen overseas, they are being enabled by contracts and by agreements that mining companies make with governments. Like what's going on right now in Papua New Guinea between the Barrick Gold's CEO and the Prime Minister of Papua New Guinea. It's going to be very bad for Papua New Guinea, but it's going to be very ironclad for Barrick. And that kind of legal expertise is very rare in the world, and we have it in Canada. What we also have in Canada is a concentration of consulting firms, environmental consulting firms that will do the environmental impact assessments that companies need, as well as a whole suite of other industries that service the mining industry. So provide wheels or for their big machines, or provide the machines themselves. So Canada is sort of a one-stop shop for mining companies from around the world. So if they're headquartered here, then they can have access to all of that expertise. That's not a simple answer. I mean, it doesn't necessarily explain it, but that's as far as we've been able to get on why it is. I think we have Bonnie Campbell here, I think, as well, and she may be able to add some information to that. But that's the main reason we're being told. Canada is also in some ways a secrecy jurisdiction. So you can actually be headquartered in Canada and provide very little information about your board of directors and your operations. And that may be more why companies want to headquarter in Canada, but that doesn't explain why they want to be on our stock exchange. Okay, and for the second part of your question, or maybe a comment on the artisanal mining, I think that's a really astute observation. And I hear this all the time. I hear it in Porgera, the other mine that I highlighted today in Papua New Guinea, as well as in Tanzania. And what people don't understand is the artisanal mining that people were doing in Porgera, and in Porgera it was literally just panning. There's so much gold in the ground there that it was just showing up in the water, in the otherwise clean and drinkable waterways, but they could pan for gold in these waterways. And it was always supplemental. It was never all they could do. They always still had their other agriculture. In Papua New Guinea, they would have their pigs. In Tanzania, they would have their agriculture and they would have their cows. But the gold was like a supplemental source of income. And now they don't, as you said, they don't have access to that anymore because it's now controlled by the mining company. And they'll always say that the company is getting our gold. They're becoming very rich, and they're foreigners, and we're left, living on the margins of the waste dumps. And even when we try to eke out a living by going into these waste flows and getting some residual gold that's still in the mine tailings or in the waste rock, we're being persecuted and hounded and abused. So it's an important point.
Okay, thank you. Mehmet, you had a question. Please unmute yourself.
Yes, thank you very much. Basically, I'm based in Turkey, and I'm representing one of the Canadian company. We have very similar situation, not with our company, but one of the gold mine company recently sued our government about $1 billion for the same situation. The name of the company is Alamas Gold. But what it makes basically also for the other mining companies, which is making their business as it's supposed to be with all environmental respect and then how it's supposed to be, because of the country's name is basically gets with such kinds of problem, the way of the people and then most of the government institutions, when they heard the name of Canada, they started to look a little bit more like we are doing something dangerous because of the other companies, what they have done. Mm-hmm. Our company is basically doing very environmental and very high-tech project all around the world, but we started to get a lot of difficulties because of those other companies' behaviors. I think what we should do, it is just an example for what I can give. We should better advertise good projects of the Canada, which is done environmentally at the same time, and how it is benefiting some of the countries. There might be definitely some bad examples, but there are also a lot of good examples are existing. And we have to get the help of the government to tell the countries not all the companies are like that. This is just I would like to add to this meeting.
Well, I would love to know the name of your company, and honestly, you could be an ally, because when we try to promote new either non-judicial mechanisms or now the mandatory human rights due diligence, which would create a judicial access to justice, one of the things we say over and over again is you need to understand that when our Canadian mining companies, like those ships of the big European countries before, go out into the world, they are the face of Canada in the world. They are brand Canada. And our brand is getting a black eye all over Latin America, in Africa, even in Turkey.
In Turkey, yes.
And in Greece, and in other European, Romania.
Yes.
I mean, these are all places where Canadian companies are suing the governments in international tribunals. But there's a proliferation of these Canadian companies suing governments for trying to do their job, trying to do what they're supposed to do to protect their people and protect their environments. And then they get sued in these international tribunals. And small countries like Papua New Guinea give up.
Cannot. That's true.
But we're always saying that, the Canadian government should be with us on trying to promote this legislation, like the mandatory human rights due diligence, because it's a way to weed out the bad apples, whether they're Barrick Gold or whether they're a small exploration company. They're the ones that are going to be sued, and the good ones, the ones who are trying to do the right thing, will actually have an easier job. And so one thing we're hoping to do is to reach out and get some allies among mining companies who think that they are doing a good job and who would promote this legislation, who would say, yes.
I will be we are definitely going to be on your ally, because we are trying to also go to that companies to show them the right way. There is a right way to do it and to make everyone happy. At the same time, it will be definitely, there is a way to do it environmentally. I mean, the places what we are going and where we do our projects, one of our main plant is in the center of Toronto, for example. I mean, it is zero emission. I mean, we can do a zero emission project all around the world. But when we go to those companies, because they already get and used to the traditional and old system, they don't want to change it because this is what they get to. But we have to also do our changing based on our environment. Now, this is one of the most important thing, and everybody has to do it. Otherwise, there will be no future for our kids.
I hope you have my email, and we can continue this conversation.
Of course.
Of course, other people might have questions, but I would love to stay in touch with you. I'd love it if you'd. I'm
gonna just send my email address here and then you can say it.
Okay, thank you. I hope someone is gonna capture the chat for me. Are there any other questions or thoughts, reflections?
We have Wendy Boyd who has a question.
Well, thank you very much for an excellent presentation. I think even those of us who have kind of been following the depredations of Canadian mining companies, was struck by what you mentioned about Papua New Guinea, because I was reading a book by Harsha Walia called Border and Rural Global Migration, Capitalism, and the Rise of Racist Nationalism. And in it, there's a chapter on Australia. And Australia has all these detention camps for migrants, refugees, offshore. They don't even have them in Australia, and Papua New Guinea, Christmas Island, and a few other places. And my point is that these countries, well, Papua New Guinea depends largely on aid from Australia, and they can't afford to refuse to allow this sort of thing. So that was just an aside. My question is, a lot of times over the years, we've seen the suggestion that, you know, people find shareholders in these companies and go to annual general meetings and stand up and you know, try and present what's actually happening, what the company is actually doing. And I just wondered what your opinion of that as a strategy. Is it useful? I mean, people have been doing it a long time, and things don't seem to change.
On that question, I do think it's useful. Simply because what you're doing, and you have to document this very well, right? So when we discovered the extent, I mean, it's a long story, so I won't go into it, but it really was shocking. When I first went up in 2006, I had people from the community themselves had written this report, and it was called The Killing Fields of Porgera Joint Venture. And they didn't have internet in Porgera at that time. They literally took a 6-hour trip through a very treacherous road through the mountains this road ends at the mine. There's nothing after that but bush, to the nearest big town, which is Mount Hagen. And they went on the internet and they looked for anyone they thought might care about what was happening. And lo and behold, this gruesome report showed up in my inbox in 2005. And in 2006, I went there thinking, because it was men that had written the report, they were talking about the killing and shooting and beating of men and boys. When I got there, I found out I mean, it's literally hundreds of women who've been raped and gang raped. And so, you know, by 2008, I guess, was the first year that we brought people from Papua New Guinea to stand up at the shareholder meeting. Now, the company completely denied this, and there were big demonstrations outside. This was in Toronto, and the Toronto organizers, like the grassroots groups from Toronto that are working on mining issues, were organizing big demonstrations outside, and there was microphones and they could speak, and all of this was recorded. Plus, we of course did press releases, and we you know, we had all of this documented. So when the company was denying, there was a record of how many years we had been telling them very publicly, and the Canadian media picked it up, and Canadian parliamentarians started to meet with these people, and we met with civil servants. We were meeting with everyone who would meet with us, and then we got legal clinics from Harvard and from New York University and later Columbia University involved, and even they testified before a parliamentary committee, and the company still was still saying it wasn't happening. It took a long time, but there was a track record. So then you could say, look how irresponsible these companies are. You have people coming and telling them that this is happening, and they're just like, no, it's not happening. And it's a very common strategy. The first thing companies will do when you bring bad news is they'll deny. They'll drag it out as long as they can till they can't deny anymore. Then, what you saw in the film, and what also happened in Portugal, is the company put in its own grievance mechanism. And it put some people through the grievance mechanism, but made them sign legal waivers so that they could never take their case to court. So, and then they gave them paltry remedy when they gave remedy, not always, but sometimes they'd give a small amount. But basically now these people are excluded from taking their cases through the legal system. And so you have to sort of fight them every step of the way, but it's one of the effective things you can do, because at least it gets it on the record that you've been raising this. And for some companies like Barrick at that time, denial was the best policy as far as they were concerned. But in the end, it looked really bad on them, because when they finally had to admit, yes, this was happening, and they actually ended up giving remedy to 119 women, and we know that that is not all of the women that, and then others did refuse that remedy mechanism and did get an out-of-court settlement. So there's another 11 there. And we know that there's more. Then it looks really bad that they actually were in denial for 4 years. So it's worth doing, but it's not going to change things overnight. That's certainly not going to be the case.
What about the pressure in the Canadian government? I mean, it seems that the Canadian government is promoting this.
This is what I perhaps wasn't as clear as I would really like to be on this, and it would be another presentation just on the role of our embassies, for example. Our embassies have a mandate, an actual mandate that they have to fulfill to promote and protect the interests of Canadian corporations operating in the various countries around the world where the embassies are. And they take that mandate very seriously. So when you bring issues to the embassies, and I brought issues to embassies in the Philippines and in Tanzania and all over, when you bring issues, that's what you're told. But Catherine, we have a mandate to promote and protect the interests. And when you say, well, what about your mandate to promote and protect Canadian human rights? Canada has an obligation to protect human rights, and that's not just in Canada. They have an obligation to protect human rights. There have been 5 human rights committees through the UN that have called on Canada to do something about what our Canadian mining companies are doing overseas. 5 treaty bodies have called on Canada to deal with the problems that our Canadian mining companies are causing overseas. And so that obligation that Canada has to protect human rights, not just in Canada, but also overseas when there's an intersection with Canada, is very clear. And yet our embassies have no mandate to protect human rights. They're not obligated to protect human rights. They're obligated to promote and protect the interests of companies, not of people who are harmed by those companies. So this is a really big problem. And the reason the NCP is as bad as it is, it's not an accident. It's kept as bad as it is. There's even been a peer review process recently by other NCPs. This was in 2018. And in the peer review report, there's clear mention of the fact that our NCP has lost the faith of the Canadian public, and that something should be done to try and regain that faith. Nothing has been done. And that was in 2018. In 2019, the UN Working Group on Business and Human Rights issued a Canada report. And in the Canada report, again, pointed on the fact that our national contact point is as bad as it is. Nothing has changed. Then we get an ombudsperson who we're told is going to have the powers that she needs to actually be better than the national contact point. Given that dire history, we need something that's better. And then, in fact, her mandate now makes her very similar to the national contact point. So it's 15 years of struggle and always with huge industry lobby against these things. There's another effort that I haven't even talked about Bill C-300, which a member of Parliament, John McKay, put forward a bill. Before the counselor, the CSR counselor was created, he put forward a bill to try and honor the recommendations of the 2007 joint CSR report by industry and civil society. And his bill went down to defeat by 6 votes, but which was close, it was pretty close. But, the lobby against that bill was unbelievably intense. He said he had said he had never seen anything like it, and other MPs we met with said there's never been a lobby like this against the attempt to hold our companies to account in Canada for what they're doing overseas. It's a huge, and our industry and our government are incredibly linked. There's a real revolving door. You often see people like John Baird, who was our Minister of Foreign Affairs, who later ends up on the board of Barrick Gold. Once he's no longer a minister and leaves the government, he ends up on the board of Barrick Gold. The relationship, and our corporations and the Mining Association of Canada and the Prospectors and Developers Association Canada, which are the lobby groups, they can walk into a minister's office and have a meeting at the drop of a hat, whereas we can lobby to have a meeting for a year and not get it. Right? There's a real discrepancy. Just recently, the head of the Mining Association of Canada co-authored an op-ed with the Minister of Natural Resources. I mean, it was a co-authored op-ed literally promoting Canadian mining. It's as though the minister is only the minister of the mining industry and not the minister of all Canadians. And so, we have really serious political problems here in Canada. And the industry makes a lot of use of that. And the only way that can change is if Canadians stand up and say, no, actually, there is a real problem here. It hasn't been fixed in 20 years. We want it fixed. We want this mandatory human rights due diligence, for example. So hopefully I'll be getting all of your emails, and we'll be reaching out to you and how you can help us with this new effort that we've just launched.
Yes, we have a question from Shauna. Shauna, go ahead.
Hi, I know we're almost out of time. First, thank you so much for the really valuable presentation. Just really quickly, I work with an organization that looks at the impact of technology on human rights, social and environmental justice. And we've been looking, in supply chains at public procurement as a strategy point in terms of lobbying, for example, public institutions like universities, their procurement of technology, and wondering to what extent, like you see that as a strategy in terms of looking at the purchasers of gold, for example, gold being in technology devices in a lot of smartphones. Is that a strategy that's sort of complementary with some of the work that's happening right now around the human rights due diligence? So any reflections, and thanks again for such an informative presentation.
Absolutely, that is definitely one of the prongs where accountability could happen. The big problem there is that in order to make a decision about procurement, so let's say it's copper or whatever it is that is needed, you need to have some way to actually make a decision about which company is at least doing better than another company. And there isn't really a good mechanism to make that decision at the moment. There is an effort called IRMA, Initiative for Responsible Mining Assurance. It's basically a certification system. I would say that anyone should take a look at that effort. It's been launched a couple of years ago after many years of development. And IRMA could in essence be seen as a way of ranking companies, because they have a list of criteria that companies need to meet. And you can actually ask for a company to be audited using the IRMA criteria. And those audits have just started. There have been a couple of companies audited, but for example, if it was the Government of Canada and procurement, they could say, okay, we're gonna ask for an IRMA audit on this company, and based on the results of that audit, we'll decide whether we're going to source from that company or not. That might be a very useful way forward.
Thanks so much. That was ERMA?
Yes, IRMA.
IRM.
For Responsible Mining Assurance. And I'm happy to put you in touch with the folks running that directly, because we know them really well.
That would be great. Thanks so much.
Thank you. I don't see any more questions unless I missed somebody, but I don't see any more hands up. I would just like to go back. I know we're just beyond our time by a minute or two, but you did mention, Catherine, something about the draft legislation. Is that, where would we find the reference to that?
Right, great. So if you can find the Canadian Network on Corporate Accountability's website, CNCA. I think I also put on the little reading list that I was asked to provide, I also put a backgrounder on that legislation, but there's all the information as well as the draft legislation that we've now tabled or we've launched ourselves are all on the site. It's a Canadian Network on Corporate Accountability, CNCA. Mining Watch is one of the founding members of that, and we're on the steering committee and have been from the beginning, and other great organizations, NGOs, unions, faith-based groups are all members of CNCA, and we have a lot of support from academics, and we have support from lawyers, really great lawyers in Canada that care deeply about these things.
Mm-hmm. Yeah, no, thank you. So we'll check that out. I'm sure everyone will. Paul, can I just ask you, we'll be producing this video putting it online?
That's correct. We will be putting it online in the next couple of days, and it will be posted on the website, peacealliancewinnipeg.ca, and as well on our Facebook pages. There'll be links as well. Yeah,
no, thank you again. And a round of applause if there's a way to show that on Zoom, or you can unmute and clap. So thank you.
Thank you very much.
Thank you.
Excellent, thanks.
Bye.
Okay, thank you. And we're finished. Thank you everyone for attending.